Hello, it is Saturday, August 17th, 2024, and this is Political Drama with Alan Zundell. I've been covering the alternative presidential candidates in this election year. By alternative candidates, I mean the non-major party candidates. And today I'm going to be talking about the progress in ballot access among the candidates who are doing the best in that regard. Now, tomorrow I'm planning to do another show, this time splitting my show into 2 weekend episodes. Tomorrow I'll be talking about a new Washington Post article that alleges Robert F. Kennedy Jr. approached the Kamala Harris campaign with an offer to endorse her in return for a position within a potential Harris administration. If you've been watching me, you may remember that I've already spent segments in 3 episodes already talking about a similar Washington Post article alleging RFK approached the Trump campaign with the same offer and taking that one apart. So tomorrow I want to dedicate a whole show to this new Washington Post article. But today will be ballot access updates, and I'll leave to next weekend what I said last week this show would going to include, which would be how the Democratic Party finally got Biden to step down in favor of Harris. So let's turn to ballot access progress by the alternative candidates. Let's see my figures here. This is my best estimate of where each of these leading alternative candidates stand. I've included all the states in which not only have they been certified as officially on the ballot, but those states in which they've done what they need to get certified, things like turning in enough signatures or paying a filing fee. But I have not included any states in which the candidate has been challenged and then there's been a decision to remove them from the ballot as a result of that challenge. Most of these challenges to their ballot access fail. And in Kennedy's case, so far it's only resulted in one win, which was in the state of New York, and I'll be getting to that in a minute. So if you look at this, if I include District of Columbia within the 50 states, we see Republican and Democratic parties have ballot access in all 51 of those. The next highest up is actually Robert F. Kennedy Jr. He's now on the ballot in 46 states plus the District of Columbia, which is 4 to go. And that doesn't include the state of New York. And then the next up is Libertarian Party at 42, although not all those states are going to have their official nominee, Chase Oliver, on the ballot. One, at least, Montana, put somebody else on the ballot. And then the Green Party with Jill Stein. I added her name because in some states she actually qualified as an independent candidate rather than as the nominee of the Green Party, which will probably happen this weekend at the Green Party convention. And then after that, the rest are pretty far down there, although, surprisingly, Claudia de la Cruz of the Socialism and Libertarian Party has outpaced the Constitution Party and Cornel West in ballot access. De la Cruz now has 16 of those, where the Constitution Party is only at 15, and I think 2 of those are not going to have their official nominee. And then Cornel West doing fairly poorly at 13, although there's plenty of candidates for the presidency who have ballot access in just 1 or 2 states, if any. That's where the things stand right now. And I'll turn now to the leading of these, which is Robert F. Kennedy Jr. And this week they had some good news, which was they gathered enough signatures, plenty enough signatures, to get on the ballot in the state of Arizona. Arizona's deadline for qualifying for the ballot was today at 5 p.m., and they submitted these yesterday. Out of a required 42,303 signatures, they submitted 110,000, which was more than twice as much as they needed. So it looks pretty certain that Kennedy will be on the ballot in Arizona. And then looking further on at the challenge that I mentioned in Maine, there was a challenge in Maine towards him being on the ballot, and there's challenges in other states going on as well. Pennsylvania and Illinois come to mind, as well as the ongoing New York case where he had an adverse decision. But what happened in Maine is the one person who had challenged Kennedy to Kennedy's right to be on the ballot was actually withdrew his petition. And here you see the actual letter that was sent This is signed by James Stretch, saying that he brought a legal challenge to Kennedy's petition to be on the ballot and withdraws his challenge to the petition. Now, who is this guy and why is he doing this? Well, he doesn't say. If you notice, there's no reason given for withdrawing his challenge, but he has been identified by the Independent Political Report as the 2020 Maine state director for the Biden campaign. So he has ties to the Democratic Party, as all these challenges to Cornel West in particular, the Green Party, and usually, well, almost, I think in every case, to Robert F. Kennedy Jr. as well. So two pieces of good news for the Kennedy campaign. Turned in enough signatures to get on the ballot in Arizona, and the challenge in Maine was withdrawn, although no one other than the person withdrawing it yet knows why. Now, given his close ties to the Democratic Party, my only guess is that they decided that Kennedy being on the ballot would be more of a problem for Trump than for Harris. So he decided, since it was only him, it would be easy to withdraw this petition without a lot of hassle and, give Harris a little advantage in the state of Maine. Early on, the Democratic Party wasn't sure how it was going to pan out, whether he's going to supposedly take votes, that he was going to do more to cripple the efforts of the Biden campaign or the Trump campaign. But with Harris enjoying favorability ratings better than Biden's, maybe he decided to drop out for that reason, but that's just speculation on my part. So Kennedy's going to be on the ballot in Maine as well, and that the original story about this was from the Maine Morning Star. Let's see. I should mention, part of the reason that he brought this challenge had to do with the residency listed as New York, and he was saying that was false, which is the same issue at stake in the New York legal challenge to Kennedy's ballot access, as well as a couple other things. They usually said a lot of the signatures are invalid, and one other odd complaint that he turned in too many signatures, because state law says you can only turn in 5,000, and he turned in nearly 6,000. That's just an odd thing there. So I reported last Tuesday extensively on how the decision, on the grounds in which the judge who denied Kennedy's access to the New York ballot put forward. I did that in a Tuesday episode that you saw, but around the same time as I was posting that, Kennedy himself came out with a video about why he did this. Now, I've trimmed the video down a little bit in order to make it more to the point. I didn't edit out, I think, anything essential. Part of it was he talked at length about his ties to the state of New York, which were not really relevant in the court case as far as that original trial judge was concerned. And he also talked about the undemocratic actions of the Democratic Party. So I trimmed it down to just the bare essentials, and I put in little beeps so you could tell where I did edit things out, and you can go see the video and judge for yourself if I did a good job, or if you trust me, here's the shortened version.
Hey everybody, we just lost our ballot access case in the state of New York. We lost it in the Supreme Court in Albany. The Supreme Court, ironically, in New York State is the lowest court in the state. And we will be appealing this. And we're very confident that in the Court of Appeals or the Appellate Division that we will prevail, that this loss is just a road bump. The rule in virtually every state is that your domicile is the place where you intend to return. Oh, I have lived in other places. I've lived in Alabama. I've lived in South Dakota. I've lived in Massachusetts. I'm living now in California. But I've always voted in New York, and I've always intended to return here. And when Cheryl and I married in 2014, we agreed that when her acting career is over, that we'll come back to New York. Here's the problem with the court decision. I was advised by my attorney, who was Paul Ross. He was arguably the best ballot access attorney in the country, that I needed to put my New York address down, that it's the only address that a lawsuit, my own, that I would survive a lawsuit. He said, you're going to get sued by the DNC no matter what state If you put Massachusetts, you'll be sued. If you put California, you're going to be sued, and you're going to be sued in the New York State Court. So probably in front of the same judge. So I acted on the advice of counsel, and when you do that, you cannot be convicted of fraud if you acted in good faith at the advice of counsel, which I did. And here's why he told me that. Most of the states require the candidate, which would be me, to use the same address on their ballot petitions. So you have to use a consistent address around all 50 states. And there are many states, including, for example, New Hampshire, that require that the domicile has to be the place where the candidate votes. Well, I've only ever voted in New York. So the only domicile I could put, and I had to swear in California, in New Hampshire, I had to take an oath in front of a notary that my voting address was my New York address. And so I had to use that address in those states, which means I had to use it in every state. And as you guys can imagine, this lawsuit is a frivolous lawsuit. It's a lawsuit that was brought by the DNC. The cost of these lawsuits by the DNC to us, to my campaign, is going to be over $10 million. Defending these frivolous lawsuits, we've won every one, and we're going to win this one. But they're using lawfare to try to keep us off of the ballot. So that's where I am today. We filed. We're filing an appeal in New York State and in the state courts, and then we'll go up to the Supreme Court if we have to. And it's an expedited appeal. These election cases get faster treatment than any other case. They get precedence over every other claim. We're also filing a federal action under the 12th Amendment. The 12th Amendment says that there's only 3 requirements for president to run for president of the United States. One is that you're 35. 2, you're born in this country. And 3, that you're a citizen of this country and a resident. And I meet all 3 of those. The states are not allowed to impose additional burdens, and the courts have been particularly wary of any state laws that could create a patchwork. They say this is a national election, it's the only national election, and the states cannot obstruct that by adding burdens to candidates appearing on national ballots in all 50 states. So we're filing a preemptive lawsuit in federal court, and we expect to win that too, and to win it very, very quickly. But I wanted all of you to know what we're doing, and to tell you the press will probably play this in a way that is disadvantageous to me, to put it mildly. And I wanted you to know what the truth was, and to not worry, because we will prevail.
Well, my only contention with his statement was why he keeps citing the 12th Amendment for those requirements to be president when it's actually, and let me show you the passage from the U.S. Constitution. This is Article 2, Section 1. If you look down way at the bottom here on the screen, no person except a natural-born citizen or a citizen of the United States at the time of the adoption of this Constitution shall be eligible to the office of president. Neither shall any person be eligible to office who not attain the age of 35 years and been 14 years a resident within the United States. Now, above that, the passage that's highlighted in blue is the section that the 12th Amendment amended. So it's not actually part of the 12th Amendment. The requirements for being president that he continues to mention are actually in Section 1 of Article 2 of the U.S. Constitution. So I don't know why he keeps citing the 12th Amendment when that's actually in Section 1 of Article 2 of the Constitution. But I will say that if they bring this case into federal court, it will be important in that a federal decision should apply to multiple states, depending on if it's a regional appellate court or if it reaches the Supreme Court. But it could knock down a lot of these ballot challenges across the country. As I said in my show on Tuesday, the Supreme Court in the earlier Trump versus Anderson case, where they tried to keep Trump off the ballot in Colorado, and it went all the way to the U.S. Supreme Court. That court has said that you can't have states having very different requirements for being on the ballot for president because it's a national election, and kicking a candidate off the ballot in one state would affect the whole overall election. So it'll be quite interesting to see how this all pans out. I don't know that they filed in federal court yet, haven't heard any word on that, but they did bring it to the appellate court in New York. And as Kennedy said, the court that heard the trial, the original jurisdiction court, was the Supreme Court of Albany, the county of Albany, so that confused me as well. But anyway, they're going on appeal now. The New York Supreme Court appellate decision is going to hear oral arguments on Wednesday, August 28th, which is about a week from this coming Wednesday. All right, let's turn now to the Libertarian Party, who has the next highest number of ballot access successes. And there they are on the ballot in 42 states, although, as I said, he's not going to be on the ballot in Montana. But in the state of Colorado, there is a fight going on. Originally, the state party said they're going to put Kennedy on the ballot on the Libertarian Party line, and then one of the National Party committee members decided to beat them to the punch and filed for their official nominee, Chase Oliver. But this week, the news was this fight is still ongoing, as we can see by this article from the Third Party Watch, stating that the National Party chair of the Libertarian Party has written to the Secretary of State of Colorado saying she wants to have them remove Chase Oliver, their official nominee, and his electors from contention. So I'm not sure what's going on in that party, but it's been a sight to behold as they go from one fight to another. Let's turn now to the Green Party. And as I said, Jill Stein and the Green Party together have gotten on the ballot in some, what did I say? I forget already, 33 states. Here, the Stein campaign finally has a map up where you can follow this, and this is on the Stein campaign website. It was updated just a few days ago. The deep green states are the one in which they're on the ballot as the Green Party. The slightly lighter green shaded states are the ones where Jill Stein has gotten on the ballot, and I've counted those, but not where they're doing write-in campaigns. I've also counted those where they submitted sufficient signatures but are awaiting certification, which would be the lavender shaded states. So you can see there, they've covered a lot of the states, but there's still a big section of the middle states there, and around the, from, Kentucky, Tennessee, Alabama, in the Georgia in the south, to the Midwest states, North Dakota, Minnesota, Iowa. So not doing well there, but farther west and in the south, they're doing pretty good, and in a few states in the Northeast. Green Party, as I said, is holding its national convention this weekend, and I fully expect Jill Stein to be the nominee. She's got enough delegates. And she did announce this week, I think on Wednesday, who her vice presidential pick would be, and that is Dr. Butch Ware, a professor at the University of Santa Barbara, California. And she, in her X post here, talks about some of his credentials, that he's been working in the history of people's movements and struggles for a peaceful world, and he's also apparently been an activist. I don't know a lot about him, but I thought that was newsworthy as far as her getting her candidate there. So the final one I wanted to talk about now, as I said, the candidate of the Socialism and Libertarian Party, Claudia de la Cruz, is doing better than Cornel West, but I haven't come across a lot of news about her. I'll have to do a little bit more digging. We're nearing the end of the period of ballot access, though, and any candidate that hasn't gotten more than half the states, I'm not going to be really paying a lot of attention to unless some unusual situation comes up. But I think this news this week about Cornel West was interesting, not only from the standpoint of Cornel West's progress, but how trivial some of the challenges can be to these candidates being on the ballot. And in the state of Michigan, they've kicked Cornel West off the ballot over what is called a technical violation of state law. This story is from the Detroit free press, and that technical violation was that he didn't have his affidavit of identifying himself, and they said it wasn't properly notarized. They didn't fulfill the legal requirements in the state of Michigan for being notarized. Now that, even though they turned in plenty enough signatures to be on the ballot, and they turned in their other documentations, they said they weren't notarized properly. There's some flaws with notarization. Now, was this legitimate? Well, a legal scholar says no, and this is a law professor who keeps a blog on election law. And here you see the article, "Is Michigan Properly Interpreting Its Own Laws and Keeping Cornel West Off the Ballot?" by Derek Moeller. Here's the statute that's at stake, and if you read through that paragraph to the very last sentence that he's quoting, it says, "The affidavit of identity," and this is the document they didn't have notarized, "filing requirement does not apply to a candidate nominated for the office of President of the United States or Vice President of the United States." And he emphasizes, they're highlighted in yellow by me, the statute expressly exempts presidential candidates from the affidavit of identity requirement. So why is that a hang-up? Well, according to this blogger, he's quoting from the statement of the Michigan Direction of Elections, and they say that candidates nominated for the office of President and Vice President are not required to file an affidavit of identity, but candidates filing to run without party affiliation by submitting petition signatures are required to submit an affidavit of identity. And the law professor says, I don't read the statute to require that at all. And what he is pointing to is that there is no division in the state law between presidential candidates running as the nominee of a party and those running as by submitting petition signatures. The distinction the Director of Elections is trying to make is that because the language of the statute says nominated, no one nominated for president or vice president, well, only a party can nominate you, and then regarding petition signatures is not really a nomination. That seems pretty far-fetched to me, as I think it would be to any fair observer. Okay, so that's the story on ballot progress to date for these independent or for these alternative party candidates, both minor party candidates and independent candidates for the presidency. We only have about a month to go in not only hitting deadlines for submitting things to the states, but for the states to actually certify for the ballot, because in a few states at least, they're going to be sending out early ballots, and in most of the states, there's people that can request early ballots for various reasons. So they have to have prepared the ballots that they're going to print up and give to people within a very short time, within about a month or so. So we're coming to the end of this ballot access ballot access process. Again, thanks to all of you for following this with me. I appreciate you watching. I appreciate your comments. I appreciate the likes and the subscriptions and all of that. If you want to show me your appreciation and you can afford it, you can give a one-time donation by going to politicaldharma.com, my website, where I don't have a lot up yet. As I said to you, if you've been watching, I just moved, and so I'm just getting settled here, and I'm packing boxes still. We'll soon be able to put some things on the wall behind me to make a little more decorative here, and also to get my website in shape, I hope. If you'd like to be a patron member and give a regular donation, I've got two tiers, one for, I think, $2.50 and one for $5, and you'll get my videos without commercial at the beginning. That's at patreon.com/politicaldharma. So thanks to those of you who have already become members. I appreciate that very much, and I hope to be generating more content for you on Patreon as I get to it. That's about it for this week. That's about it for today's episode. Please check in tomorrow, because I should have another one about that Washington Post article. Thanks a lot. Bye.
With ease, I see the chains are breaking. We gained our focus, the moves we're making will prove to determine our self-worth as a passenger on this vehicle Earth.